Hey folks, James Abrinio coming to you from Abrinio Cho, your Northern Virginia personal injury and criminal defense law firm. Wanted to give you a quick update. If you've been paying attention to the news, you're probably aware that recently, um, through the direct or indirect suggestion of President Trump, the Department of Justice has charged James Comey with, I think, lying to Congress, I believe is the charge, about statements about whether or not he was authorized to release or leak information about an investigation against Trump. Um, as I've said a couple times on this channel, my goal here is not to make this a political podcast, but really do my best to teach you watchers about Virginia law. Again, we do personal injury, we do criminal defense. Most of my practice is in state court. This case is pending in the Eastern District of Virginia in federal court. It's obviously a criminal case. So we do criminal law, and it's right next door, essentially. So I did think it would be super useful and really an educational tool for folks trying to learn about our system. And what is uniquely interesting, scary, but interesting about this case is what it appears to be vindictive prosecution by the Department of Justice, essentially at the urging of Donald Trump to go after political foes. I think even if you're on the opposite side of the aisle, you could probably agree that this is not an overstatement. What's fascinating is, I guess, in order to get this charge down the pike, essentially before the statute of limitations ran, essentially Trump appointed a non-prosecutor, Lindsey Halligan, who apparently represented Trump on different other matters. Sounds like she's more of an insurance attorney, civil attorney, to come in and prosecute kind of one of the most high-profile cases that you can imagine in modern history, where you have a president effectively directing a prosecution. So it's clearly going to be a high-profile case. When you do that, there's a lot of questions to be concerned, but there's also kind of a competency concern when you have somebody that's never prosecuted a case to come last minute to try to get a criminal indictment held. So apparently she went before the grand jury, ended up getting an indictment against Mr. Comey. And now the defendant, Mr. Comey, has filed a couple of motions, one being a motion to dismiss for vindictive prosecution. And as part of that motion, they've also asked for the grand jury information in order to get more information. And I've got to just post a few interesting, just really crazy statements made by the judge handling that motion. And by crazy, I don't mean on the judge's part, but just the fact that this is happening is pretty intense. Really not things that you would really expect, especially from I think somebody that is well practiced in criminal law, that has prosecuted cases, to understand how these are going. And so this is a finding. This is a conclusion. You can go look up the entire documents for yourself. But this is a finding by Magistrate Judge William Fitzpatrick. So to quote this here, the court recognizes that the relief sought by the defense is rarely granted. However, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding. Therefore, in this case, quote, the court has before it a rare example of a criminal defendant who can actually make a particularized and factual based showing that grounds exist to support the proposition that irregularities may have occurred in a grand jury proceeding and may justify the dismissal of one or more counts of the indictment, end quote. And there's the judges, obviously, the magistrate judge is quoting a case here, Nagel 474 F supplement second at page 10. So the court there is essentially saying, look, this doesn't happen often. Whatever finding we're going to be finding narrow to the facts of this case, but we're essentially going to allow the defense to have access to grand jury materials because we think that I think based upon what the court is seeing, the defendant has made a particularized finding that it's justified. So that is a rare step. Again, I don't practice federal court, but the fact that the federal magistrate judge here is saying that this is rare should be telling and should be indicative of what may be coming down as far as this case is concerned. Now, The other thing that I wanted to share was part of the opinion. I found this. I was on Blue Sky. It's kind of the liberal version of Twitter, but people are sharing parts of the pleadings here. And here, the judge's opinion. This is earlier on, presumably in that order written by the judge, but it's really fascinating, and it really highlights the distinction between practicing criminal law and practicing civil law, and the important uh, and sincere treatment that you must apply to the Fifth Amendment. The Fifth Amendment is the right as a criminally accused to not incriminate yourself, the right to not testify, and the fact that if you assert your Fifth Amendment right, that any fact finder, whether it's the jury, the judge, or the grand jury, when it comes to somebody's criminal culpability, cannot use the fact that that person is not testifying against them. That is a fundamental principle in criminal law. And so here you have the court really making some just fascinating findings that you just don't expect to see from seasoned prosecutors. And I'm just going to go statements of the prosecutor of the grand jury. And this is obviously redacted, so we're kind of reading into it. It is what it is, so we'll take the best. Having been requested by the government to review grand jury materials, the court has identified two statements by the prosecutor to the grand jury that on their face appear to be fundamental misstatements of the law that could compromise the integrity of the grand jury process. Both statements by the prosecutors are in response to questions by the grand jurors and are directly related to communications involving Mr. Comey. First, after having advised the grand jurors that the prosecutor was their legal advisor, and this ECF, presumably this is references to the transcripts themselves, the prosecutor stated, and then it's redacted. And that's likely because, again, I don't do a lot of federal work, and so I don't do a lot of grand jury work. But likely it's because the grand jury proceedings are privileged at this point, or shielded. They're not disclosed. The prosecutor stated, and it's redacted. And then the prosecutor's statement that and then redacted is a fundamental and highly prejudicial misstatement of law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right to not testify at trial. The prosecutor's statements ignore the foundational rule of law that if Mr. Comey exercises his right not to testify, that the jury could draw no negative inference from that decision. So essentially, we can gather from this opinion that Ms. Halligan essentially represented to the grand jurors that there effectively is no Fifth Amendment right, or she simply didn't explain it well. And so obviously we don't know what the grand jury specifically asked. We don't know exactly her statement. But when it comes to addressing Fifth Amendment rights, when it comes to a fact finder, to a grand jury, or to a jury, you have to understand when it comes to criminal law, the defendant, the accused, not just the defendant, the accused, somebody has not been criminally convicted of a crime. The accused has a Fifth Amendment right to not incriminate themselves, to not testify. They have no burden to present evidence, and the fact finder cannot use that against them when it comes to guilt or innocence. That is fundamental. That is very, very different than a civil case. So I do injury work. And so if my client has sued somebody for, negligence or even criminal assault, in a criminal case, if that person is being prosecuted for criminal assault, for instance, the fact that they don't testify can't be used against them. The government bears its burden to prove guilt beyond a reasonable doubt. And the fact that the defendant chose not to testify cannot be used against them. So a prosecutor can't go in on a criminal assault case and say, look, obviously the defendant didn't testify. They must be hiding something. They can't do that in a criminal case. In a civil case, it's very different. If you're working on injury work and I've sued somebody for a civil assault, I, as a plaintiff's attorney, could say, look, you heard my victim testify that the defendant, assaulted them, whatever assault it is, and you didn't hear the defendant get up and say he didn't do it. And unless they had a valid Fifth Amendment right, let's say that criminal case has already been prosecuted and then I've brought that civil case up and I've sued them, I can use that as a victim's attorney, but you can't do that in a criminal case. And I think this is, and also let me just check something really quick. I thought there was another interesting point. Yes, this is also another quote that was highlighted on Blue Sky. Sorry to go back to that. Second, the prosecutor told the grand jury, again, it's redacted. The statement clearly suggests to the grand jury that they did not have to rely on any record before, on only the record before them and to determine probable cause, but it essentially assured that the government had more evidence, perhaps better evidence, that would be presented at trial. So apparently, Ms. Halligan must have made some other type of representation about, again, I'm not sure if it's in reference to a question asked, and I'm not even sure exactly what she said, but based upon the court's finding, there was some type of representation that the Ms. Halligan made that, you can essentially assume that there's going to be more evidence presented at trial that's going to be beneficial to the prosecution. So, and when it came to finding a probable cause. So when you're talking about a grand jury and when they're issuing an indictment, the threshold that they're looking at is a probable cause. When you're looking at convicting somebody beyond a reasonable doubt, the government has to prove beyond the reasonable doubt. When convicting them, you have to establish guilt beyond a reasonable doubt. So there's different thresholds. That being said, even though there's different thresholds and different hearings between an actual criminal trial and a grand jury, you still cannot misstate what the Fifth Amendment holds. And so, again, it is a very huge distinction between civil and criminal law. It's also a very big reason, especially on a high-profile case like this. It's going to be one of the most reviewed that you can imagine. It's going to be all over the news. You're going to have every person, unless they're living under a rock, reviewing what's happening in this case. And to go and have such a fundamental misstep, I can comment about whether or not it was ethical to bring this in the first place and all that. I'm going to leave that for other folks. But when it comes to just pure competence on a high-profile case like this, that's the reason you want seasoned prosecutors handling these cases, handling grand juries, handling the prosecution. Because if you're messing up on things as fundamental to the Fifth Amendment, there's going to be real issues. Now, whether or not, and I think it was pretty clear that other line prosecutors effectively resigned because they were not willing to bring these charges. And I suspect part of what's happening here is you need to bring in somebody with a lack of experience so they don't see what a huge red flag is presented by bringing this case. Maybe that's what's happening. Maybe it's bad faith. But that being said, there's a fundamental flaw in that process. To not understand the Fifth Amendment and present that to a grand jury, that's a huge thing. Now, look, I am not a perfect lawyer. I have made a lot of mistakes in my practice, and I will continue to make mistakes. Every lawyer that is trying cases, high-profile cases, and not even high-profile cases, just run-of-the-mill cases, we're all going to make mistakes. That's just the name of the game. If you're not making mistakes, you're just sitting on the sidelines. But when it comes to something as fundamental as the Fifth Amendment and misstating that, that's a huge, huge issue. And I'm glad that this magistrate judge, again, I haven't worked with Judge Fitzpatrick before. Again, I'm not in the federal system a lot, mostly in state court. Some of my civil cases gets removed to federal court. I've had criminal trials in the federal court, and I do a little bit of work there, but mostly based in state practice. But I'm glad that this judge is stepping up. I think this is a huge signal to what ultimately may happen. Now, obviously, no one knows what's going to end up happening in this case, whether or not it's going to be dismissed based on selective prosecution or whether it will not be heard on the merits and there'll be a conviction or not. Based upon, what I'm hearing, it sounds like a very, very questionable case. And I would never want to sign my name to it, but that is what it is. So hopefully you find this useful. If you got questions, comments, feel free to comment below. Wish you guys the best. If you're a lawyer, especially a young lawyer, be paying attention to this stuff, not just for the politics, but you can learn a lot. And if it's also learning from other people's mistakes, that is the best way to learn, because you'd rather learn from other people's mistakes than your own, because then you have to suffer consequences. You will make mistakes as a young lawyer. You will make mistakes as a seasoned lawyer. I don't know if I'm a young lawyer or seasoned. I'm probably somewhere in between. I'll continue to make mistakes. I'm not going to judge folks on making mistakes. But this is, again, one of the highest profile cases you can get. to mess up on something this fundamental is pretty crazy. So wish you guys the best.